Good morning, everyone. This is Helen. Dee Dee and I are sharing a computer today, so neither one of us will be on camera, but that's always better for the recording. And just to remind you, this is being recorded and will be posted later. We are going to go through our agenda. We kind of took questions that we were getting a lot of questions about, and nobody had submitted certain ones, but as we go through this, definitely if you have other questions, we will answer those too. So once again, we're going to ask you to sign in. This is a way we're being told to take our attendance, and this kind of goes hand in hand with what ODE wants or DEW. So if you would take time to either go through the bit.ly and sign in for attendance or do the QR code, we'd appreciate it. Okay, I'm going to tell you today's topics: dyslexia and RIMP requirements for non-public schools. We've had a few calls about that. Future planning section of IEP. Who attends meetings for foster care or court-placed students with disabilities? Who needs a surrogate? Delegated nursing, reevaluation timeline, and OEC changes on goal compliance, SDI, and accommodations. Oh, yes, there's been an update. Okay, Dee Dee, take it away.
All right. So our first question is really just about the new dyslexia requirements, and obviously the new requirement for students who are not on grade level that a RIMP will follow them until such time that they are reading on grade level. Does that pertain to non-publics? And the short answer is no. The dyslexia support requirements do not pertain to chartered non-public schools. They do apply to community schools. Community schools are public schools in the state of Ohio. The one thing we have not gotten an answer on is the RIMP situation. We're going on the assumption right now that if you don't have to meet the dyslexia requirements, you wouldn't meet the RIMP requirements either at a non-public. But if you've got students who are placed out, that's important for you to know.
Okay, and this may seem like a little odd that we're answering future planning again, but there are new people and we've had some calls about. In the future planning section, is the response to come solely from the parent or should the team add their input? It should be both. You're a team. And a lot of times the parents will give you enough information, but as the student grows older, there should be some input from the team also. Definitely there it is. Best practices include the team's input when it aligns with goals in the IEP. And also it's really important when we start getting into the transition section because, you know, you might want to add some things to the future planning or have some discussion at that time about maybe realistic and non-realistic goals, or just where, you know, helping the parent or the students see what they might be looking for, what course of study they might be looking at, or, you know, just little things like that. Some parents will give you a lot of information and some don't need, and some need a little more guidance. So it really is a combined team effort, but definitely parents have a say too.
That's such a good point, Helen, that you brought up about our older students. It is when we have students as they get older, they absolutely should have a say in the future planning, what they want to see happen, what they want to work on, and they want to improve. So yeah, it really should be everyone.
And quite honestly, if you can get kids, I know it's difficult, and I've preached this for a long time, and I definitely have had parent pushback, but if you can get kids at a younger age attending their IEPs,
yes,
then it's not like this, oh my gosh, what's going on over there, or what's wrong with me? Or some kids don't even know they have an IEP. But they need to know it's not a, I don't know, it's not something horrible, but I just think, as kids get older, then they can learn to be a self-advocate for themselves. They'll participate, they'll be more understanding of their needs and their strengths. So just a little plug for
absolutely having kids for we've
having
always
kids
said
attend
that
IEPs.
yes, and this wasn't on our agenda, but it's just free extra bonus material that Helen and I are both huge advocates of, having even students with very intense, complex needs, even your students who are nonverbal, they can still participate, even if they're only in the meeting for the first 5 minutes and they use a Big Mac switch or pictures to greet everyone. Getting them comfortable with being in that meeting is important, like Helen said, so that as they get older, they do feel more comfortable and they're able to have some self-advocacy and self-determination about their future. So
this actually came up at a PD I was at yesterday, and they were talking about a student, not by name, and they said, he was coming to his IEP, but he was intimidated, and he's a student with probably specific learning disabilities. He was intimidated by walking into the room, just like our parents often are, because here's all these people sitting around the table that some of them he has not interacted with as much. So and their comment was, had he known about his IEP and possibly attended, he would have been more of a willing participant.
yes,
so
absolutely.
Yeah, so when we had this slide come up, I thought, well, I'm going to jump in here because this just came up at a meeting and about transition. So
it's a good time to talk about it.
Yeah.
And even having kids, like I said, if there are students with very complex needs, even if they attend for 5 minutes, giving them something to do, even if it's the introductions and they use a communication device or pictures, but older students can create a PowerPoint to say what their strengths are, what their needs are, and who their support people, who's the team that supports them. Anything like that is huge. It goes a long way in creating that self-advocacy. So again, that really wasn't part of our agenda, but it's just bonus material.
that's Helen getting off topic. Who should attend meetings for students who are in foster care or who are court placed? And I did just send out to on the special ed listserv guidance from the state, from Karen Johnson's office, when they made up the new modules for surrogate parent training, which are intense but very good. They sent out a guide sheet, and I sent that out. So if you didn't receive that, I'll send it out again, because it's something that it's, I think, only a couple pages, but it's something you can just have right sitting next to you. But basically, if the student is placed in your district via foster care or court place, you should coordinate and invite the child's district of residence representative. In terms of who acts as parent, it totally depends upon whether the parent has retained their educational rights. Now, a student could be in foster care, but the parent still could have educational rights, and you would not assign a surrogate at that time. We have to look into, just what has been retained as far as rights. And if a foster parent wants to attend, they're not signing, but if they have the student, the foster parent certainly can attend the IEP.
Right. They can attend. They just
can't.
They can't sign. And like Helen said, one of the things that we have found, especially the last few years, there's been an uptick in districts actually assigning a surrogate when they should not have. And so this is something that's come up multiple times, and that's why we wanted to talk about it today. So when you think about, when does a student actually need a surrogate parent? There are 4 specific times that the state identifies when a student must have a surrogate. But sometimes, like we said, districts actually think they need a surrogate and they assign one when they really shouldn't. And we do encourage you to check out what Helen's already put out on the listserv, like we said, because it's just a handy reference that you can use. But really, again, it always comes down to, what educational rights the parent has either maintained or have been stripped away. So the 4 times when you have to assign a surrogate are, number 1, you cannot identify a parent. The parent can't be located after you've had reasonable attempts and efforts. If the child is a ward of the state, and if they are an unaccompanied homeless youth, and that has a very specific definition under McKinney-Vento. So if they meet that criterion as unaccompanied, then they would again be assigned a surrogate. Don't mistake that just because they're homeless, that doesn't automatically mean they need a surrogate. It's if they're an unaccompanied. So those are the 4 times. But again, as Helen already mentioned, you have to remember that you have to look at where the status is of the parent's educational rights. Just because a child is temporarily placed in the custody of the Department of Job and Family Services, so they're temporarily in foster care, does not mean that a parent's rights were automatically stripped. That is a court decision, and unless the parental rights have been terminated, then, and that means that, DFSS has permanent custody of the child, or a court order specifies that they have no educational rights, they have no decision-making authority, then you must attempt to have the parent participate in meetings and gain parent signature and parent consent. You would not assign a surrogate at that time. And again, biological parent would continue to be included in your IDEA process and afforded all of the procedural safeguards that you would, for any other child. So again, that important reminder that just because they're in foster care does not automatically mean that they need a surrogate. And the other thing that has come up quite a bit in the last couple of years, we've had a lot of questions around is, well, what about when parents are divorced? So if the biological parents are divorced, but both have retained their rights to access their child's records, unless there's a court order saying, mom or dad do not have rights, then they both have equal access. It doesn't really matter who the child lives with. Both parents still have equal access to their records and can make decisions and sign, any of our documentation. Now, when you have a court order saying otherwise, then obviously you're gonna, go with that. But one thing that we wanted to just remind you of too is just because a child, one parent is designated as the residential parent, that again does not pertain to their educational decision making. That is literally only for enrollment, not for any decision-making authority. That just says this is who the child lives with, and that's where the child is entitled to enroll in that district. It does not negate the authority of the other parent to make decisions and be part of that process.
And sometimes you'll have some disagreements with the parents, and I've been in a few of those IEP meetings in the past, but then, that's where you use yourself, the team, to kind of help facilitate some common ground.
Right.
And sometimes there are times you may have to hold a separate
meeting. I was just going to say that, Ellen. Sometimes you have to do double meetings. If it's really contentious and you have 2 people who can't be in the same room together, then you have 2 meetings, and that's okay too.
Are non-medical educational staff allowed to perform certain medical tasks for students, and when? Okay. If a staff has been trained to complete non-critical nursing tasks under the title of Delegated Nursing, this can include tube feeding, I can't talk, suctioning, injecting anti-seizure meds. Here are the steps to follow. So what I'm going to say is you've had to be trained, and we know in this day and age, public schools have some of the most significant students with medical needs in their buildings. It's become a little more recent for certain counties that maybe have a DD had a DD school or still have a DD school, but in Summit County, it's been that way for at least 10 years. So here are the steps to follow. Your staff will need to be trained by a certified nurse or physician. The professional must observe the staff member carrying out the designated nursing task a few times and then confirm in writing that they're competent to complete the task. Usually this is done through giving a person a simple certificate.
And that could be a certificate that they make themselves. Yeah, it doesn't have to be anything fancy or formal. It's literally just the nurse or the physician is saying, yes, I have observed the staff member. They are competent and qualified to complete this, this delegated nursing task, and I'm signing off on it, basically.
And I know in some situations, the nurse, and some kids will come with a nurse, and that's their one-on-one nurse. And that has happened too. So that nurse takes care of all that individual student's needs. Now, sometimes you will have staff that doesn't feel comfortable. Well, I would say in these cases, they might have a little more training in that. But I think because I have had a question about this just recently, you need to make sure in your job description, especially for paraprofessionals, that these are some things you may be asked to do. You will be trained, but you may be asked to do these things as part of your job. And as long as you're trained, you're allowed to do that. Because I have heard recently there's been a lot of pushback by a couple of some parapros, nothing against parapro. DAD and I started our teacher education being a parapro and then going on. But yeah, I mean, I know sometimes it's very, it can be scary at first for certain things, but you can be trained, you can learn how to do it, and it's necessary.
Absolutely. And that's such a good point that that really should be a part of job descriptions for folks who are going to work with students with intense needs or who have medical conditions. Even down to, if you've got somebody with a very severe allergy, the only one in the building to be able to use an EpiPen should not be the school nurse. Because if you're outside with students and a kid gets stung by a bee, somebody besides the nurse who could be, in another building, needs to be competent and qualified to use the EpiPen. So it's really no different. It's the same thing. And like Helen said, you're training and then practicing with the guidance of that nurse or that physician, if the case in whatever case may be, but until they're comfortable doing it on their own. And then finally, we just have on the screen, just so you know where you're going to document that, you're just putting it in section 7 under those services to support medical needs. You're just writing delegated nursing, and you're explaining that the staff are going to carry out some of those non-critical needs or tasks. And you might say what they are, if it's tube feeding, if it's, occasional suctioning, or it's positioning in their wheelchair, whatever it is, and that they've been trained and will be doing so under the direction of the school nurse. So it's pretty straightforward and simple. Okay, so another question was, we know that the new operating standards went into effect in July, and there was some discussion last year that there was going to be a change in the language for the renewal ETR, that the reavals would have to be done 60 days from parental consent, because in the current operating standards, that language was not there. And so, we always said that's a best practice, but it wasn't necessarily mandated. So the short answer is this: the language did actually not change. So we've looked, I actually went back and read it 4 or 5 times, and it's not there. So we did think that was going to happen, but apparently it did not. So it is continues to be a best practice, but not mandated. So, but again, best practice would be that you would always try your best to do that 60 days from the time you get consent for a reeval. just a caution to remember that only applies to your in-district students. When a student transfers in from another district or another LEA of some kind, you have 30 days to either accept and adopt that ETR or gain consent for a new evaluation. And in those cases, you do have 60 days to complete it from the date of consent. So your timeline does start and you are on the clock for students who transfer.
Updates from OEC, OEC, hot off the press. Okay, you may now say, given instructional level text or given instructional level math word problems in the condition of the goal, as long as you explain in the plot what the instructional level is. Now, Dee Dee and I were kind of blown away because we were just in an IEP monitoring training. And when we heard this, we're like, shooting our hands up, unmuting, whatever. When did this happen? So what we're going to do is explain a little bit of what they said.
So, like Helen said, we almost fell out of our chairs because if you've been around us for any length of time, you have heard us say loud and clear, you cannot say instructional level. You have to either don't say anything about the grade level, either just say given informational text or given literary text or given, double-digit multiplication problems.
And let me just jump here and say, this was told to us. This wasn't a Dee Dee and Helen directive.
Right, exactly.
This was found non-compliant previously.
Yes. So for years, that has been the guidance. So we were pretty shocked when we heard an OEC monitor refer to instructional level, and we asked for clarification. And they did say there had been so much pushback by districts in recent years because of feeling that when a student's IEP went from one grade level into the next during the life of that IEP, they felt pressure to go in and amend it if they said, fourth grade or third grade or whatever, and the student's grade level changed. So that's why they said they're allowing this. But again, you have to say in the plop what the instructional level is. So here's our big caution. Do not misunderstand what this means. This does not mean that you can give students material that are not grade level appropriate. This does not mean that because an 8th grade student has a 3rd grade reading level that you give them 3rd grade material. That's not what we're saying. It just means that if the student's IEP lasts between 4th and 5th grade, you don't have to specify which grade level in the goal. And you've probably heard us say this before, but this is kind of one of those bonus moments of content that we cannot stress enough. You always need to use grade level materials for students. It doesn't matter what their reading level is. Then you adapt and simplify the reading material, but the content should be grade level appropriate. And I always chuckle because Helen loves to give the example, and it's true. And it always makes me smile when she says, you don't want to walk into a high school classroom just because the students are low incidence students with complex needs doesn't mean they should be doing worksheets with duckies and unicorns, things that you would give a kindergartner or a 1st grader. That's not age appropriate.
Yeah, and some of these students definitely have modified curriculum and you're working off extended standards or but you keep it age appropriate. That's another one of mine where people get upset with me sometimes because I say age appropriate. But just like Dee Dee says, you're not going to go into a high school and see kids working on a kindergarten level. You can modify things as you need for that individual student, but you still don't pull out a kindergarten.
Exactly. And if they're, a student who has a specific learning disability,
definitely not.
Same thing. It's even if their reading level is below the grade level they're in, you are still using grade level content.
because you need to close that gap.
Exactly. All right. So, on to our next updates. For specially designed instruction. In the past, you've been able to combine one-on-one and small group in the same box. You could say specially designed instruction, one-on-one small group in drawing inferences, and then you would list your methodologies and the strategies that you were going to use. They do not want you to put those in the same box anymore. If you are going to say one-on-one and small group, then you have to separate them. They each have to have their own line. Or the other thing they said was acceptable is you can simply say small group. And now they really are saying a best practice is to quantify what that means. So in parentheses, you would say up to 6 or up to 5, up to 8, whatever that the case may be. And that actually covers both one-on-one and small group, because what the monitor said was, if it's one-on-one, if it's the student and the teacher, then it's a small group of 2. If there are 3 students, then it's a small group of, 4. So, and we did add in our Canvas course for Beyond Compliance IEP, a 7.5-minute video going over some of these updates in more detail, to really kind of help you tease out, do you really need to have one-on-one and small group separated? If the strategies and the specially designed instruction are going to be different, so if the pedagogy is going to be different, what you would do one-on-one versus what you would do in a small group, then you should separate them and have 2 separate lines. But if you're going to use the same strategies and interventions, whether it's one-on-one or small group, then don't. Just say small group up to 5 or up to 6 or whatever, and then you're covered both ways, whether it's one-on-one or small group. And then again, best practice is to state the size of the small group parenthetically, either by saying up to 6, or they did say this is particularly true for our high school kids who are in, inclusion settings, who their class size may change from one semester to the next. They did say they would also accept if you say it like 20% of the total class size or 15% of the total class size, instead of saying up to 5 or up to 6. But one thing that they did bring up at the state, and I can see the point, is everybody may have a different interpretation of what a small group is. And they did say that they had walked into a classroom where it was on students' IEPs that they were supposed to have small group instruction, and the small group was like 16.
Right.
That's not really a small group. So better to define it and kind of quantify what you mean by a small group.
Okay, we talked quite a bit there. So let's open it up for questions about anything. If you have any questions about what we just went over, and then we'll open it up for other questions too. Again, as always, you can unmute or you can throw things in the chat, and we will do our best to provide clarification. Or if, like Helen said, there's something else that you want to discuss, that's fine too.
Good morning, ladies. It's Liz.
Hi, Liz.
How are you?
I'm good. How about you?
Good. I want to go back to the RIMP stuff and what have you. The guidance that I'm understanding is if a kiddo is alternately assessed, they also do not need to be on a RIMP, correct?
No, that is not correct.
Yes, and we were shocked.
So just so you know, and again, we have pushed back a little,
yes, we have.
and we have asked for some additional information from the state. But right now, for the dyslexia requirements, there are no exemptions. So even if a student is alternately assessed and they're exempt from the 3rd grade reading guarantee, they are still not exempt from the dyslexia diagnostics. And you may be asking why, and that seems to not make sense, because if they're exempted from the diagnostics that go along with the third grade reading guarantee, you would assume, but no, that is not the case. There are no exemptions at this time for the dyslexia requirements. And so, you know, we've asked for clarification about the RIMPs. Because if the only way I would say is that they don't have to have a RIMP is if you are excusing them from the third grade reading guarantee, which is separate from the dyslexia requirements. So if you are excusing them from third grade reading guarantee and they're excused from all portions of that, not just the retention provision, because remember, for third grade reading guarantee, there's 2 stages of exemption.
Correct.
A student can be exempted, you know, just from the retention provision or the whole thing. If they're exempted from the whole thing, then yes, they're exempted from a RIMP.
Okay. All right. Okay, good.
Okay.
And then my other question, kind of along the same lines, and we've been having quite a few of our kiddos on IEPs that have reading goals and what have you, that are not getting title services. And they're pretty low. Is that something that is a thing where once you go on an IEP, you don't get title?
You know, and again, it can vary district to district.
Yes.
But you know, typically Title I is intervening before there's been a referral and a student's been identified. It doesn't necessarily mean that a student who has an IEP couldn't still receive title services, but generally, once you are at the level that you're on an IEP, you're getting intensive intervention because you've clearly got a goal aligned to that deficit, that need, and you should be getting more minutes than you would be getting in title anyway. So that's why typically you would see, you know, kiddos who are on IEPs who are getting intervention and specially designed instruction, you would typically maybe not see them getting title. It doesn't mean that they can't, but again, that's typically why, because they've already crossed the threshold beyond that.
Okay. All right. Thank you. That helps.
Okay, yep. Thanks. Any other questions? And we'll pause for a little bit and then we will turn off the recording.
Actually, I had another question.
Okay.
Sorry. You know me.
Don't be sorry. That's what we're here for.
All right. So the whole foster care, court place, you know, surrogate, needing a surrogate and what have you. When we were at the legal update a while back, we had asked one of the attorneys, what do we do and how do we find out if a parent's educational rights are intact? How do we know that? Who tells us that?
That's a great question.
It's a great
and
question.
One of the things we always say is we know sometimes that does actually present a challenge.
Yes.
And you have to just do your due diligence to find out. Sometimes you may literally have to have someone in your district contact the court system. That is usually because sometimes parents aren't going to be forthcoming about that, to be honest.
Right.
And so usually what we tell districts to do is have someone actually contact the court system and say, you know, we need to know because we've got a student with the disability and we have to know if we need a surrogate parent. So because it isn't always provided for you. And so again, sometimes parents may want to sort of, keep that information quiet. So yeah, all you can do is do the best that you can, do your due diligence. When you would, I don't want to say be in trouble, but when it would become an issue is if you just were automatically assigning a surrogate without doing, again, your due diligence and making, concerted effort to find out if the parent had been stripped of their educational rights. So if you had done nothing and you're just blanket assigning a surrogate, that's a problem. If you've attempted it, and same as you do with everything, we always say, what do you always hear us say? Document. So document your attempts, that you've done that. And if you can't come to get a clear answer, then sure, if you believe that the rights have been stripped, or if you've got
Or
some
you can't find anybody.
you can't find anybody, then of course, we're not going to leave a child unprotected. You're going to assign a surrogate. But our caution is more that what we are finding is districts tend to over assign surrogates when a parent still has, their full capacity of rights, and they're not even making an attempt to have the parent participate. So,
Yeah, and it could be a temporary placement for the
Right,
student due
right.
to whatever. And,
and doesn't mean that the parent has lost their rights. So, yeah. So
We had just had a recent situation where we actually contacted the case, the caseworker and asked, all right, does the parent still have educational rights for this exact reason? And we were told specifically that we weren't allowed to know that.
Well, that's not true.
Yes,
you are allowed
true.
to know, because you have to know. And so, yeah. So,
like, okay, so what do we, and so we said, okay, so then if you can't tell us, then we have to get a surrogate because we can't get a hold of this parent.
I would say, okay, if you can't tell us, we can't find the parent, then we have to assign a surrogate, because back in the day, a lot of case managers used to say they were the person that was going to sign the IEP.
And that's
not true.
Yeah.
But I would document that, and then I'd get a surrogate, because
well, and the other thing is, even before you take that step, just because they say that, I contact the court directly, or tell the case manager, you need something from the court.
Yeah.
If they're not allowed to tell you, because them saying that you're not allowed to know that information is not correct. You have to know that information so that you're actually following the law. So if somebody gives you, a line like that, you need to just push back and say, no, that's not accurate. You have to know. Not only are you entitled to know, you have to know. And
to protect the students' rights.
To protect and the family's rights. That you are not bypassing a parent's rights inadvertently because you don't have the information correct. So yeah, you would tell them then you need to hear from somebody at the court level if they're not willing to share that.
Because sometimes, especially now, and since COVID, it's hard to get something from the court going directly through.
Yeah, we've been trying to get some kind of an alert in our, in our SPS program, just so the staff knows, like, do we need a surrogate? Don't we need a surrogate with this situation? And it's just not an easy thing to, and it changes all the time with so many of these kids,
Right.
Yeah. And we totally understand that. Yeah, it is. And it can, like I said, it can be difficult. And, so yeah, and that's why we say document your attempts too, that, make sure that you're showing that you are in good faith, making, every effort to involve the parent and determine if a surrogate is actually needed.
Yeah.
Good questions, Liz.
Yep.
Okay. Thank you, ladies. Appreciate it.
So we have great wait time. So Helen and I are going to just pause and be quiet for a minute to give everybody a chance. If you've got anything else you want to talk about before we, kind of wrap things up for the morning.
I have a question about writing a PR01.
Okay.
Sure.
So I found out yesterday that one of my ISs put me in a compensatory ed situation. So we are having the meeting today, and we are admitting fault immediately. And I already have a plan. Does the PR01 just need to have the plan documented? What is the best course of action for that?
That's a great question. So,
Mhm.
you do not have to outline the entire plan in the PRO1. You have to reference that there is a plan in place. So in the
Okay.
PRO1, you're going to say, these are the circumstances that, led to compensatory services. The district is going to provide the student compensatory services. You may say how many minutes or, whatever that looks
Okay.
like. You may give that total, but you don't have to detail the entire plan. You're going to explain that you have a written plan to implement, the provision of the compensatory services, and that, that is that will be put in place. And I would say your timeline
Right.
in your PRO1,
Okay.
when that's going to go into effect, when it will be implemented for the duration of time until, minutes are made up or whatever. And I would say, like, you're going to provide whatever it is, 230 minutes or whatever the case may be, put all of the basics in there. But yeah, you don't have to include the entire plan in there, as long as you make it clear that you are going to provide the compensatory services and for how long, when they're going to start, and all of that good stuff.
Okay. Would it be best practice to physically type up a plan so that then I can
Yep.
Yep.
and have everybody sign off on it?
Yep,
Yes,
Okay,
absolutely.
that's what I was-
Yeah.
Yep, absolutely. And get a parent to sign it.
Yep, that's what parents are coming in today. I hope that they agree to it. So
Well, good luck.
Good
We hope
luck.
so.
Yeah.
too.
correct. Thank you.
QR again.
Yep, let me go back. Thank you for asking. We really appreciate you guys. Sorry. We really appreciate you taking a moment to sign in. As Helen mentioned at the top of the hour, this is a new requirement that was not imposed by us at SST8. This is something that the state has asked all SSTs to do. So we really do appreciate you just taking a moment to do that. You can either use the tiny URL or the QR code and just kind of, put who you are. I think they ask you to identify your, your district, your region, and get that in there. So, and that also makes sure that we give you contact hours for participating
right.
today. And our rule is you get an hour contact hours. If we end a little bit early, you still get an
Yeah,
hour
definitely.
every time. So we want to make sure you get that as well.
Should we stop recording? Okay, we're going to stop recording and see if anybody else has anything further they want to say.
Okay, so we're going to officially say thank you for coming today.
Yes.
And before I stop the recording, though, I do want to just throw up on the screen here a reminder for January, because we skipped December since most of us are off for a good bit of time during December, but we will have our next office hours January 10th, and those will also be a morning session at 9 a.m. And so we just want to remind you to register for those. We'll put a reminder out in our newsletter ahead of time. But again, you can just go to our website and click on professional development events, and that's where you'll find it.
And we're going to just say once again, if you have questions from staff, since a lot of them can't get on, I know Dee Dee put this out in a letter prior, but if you can, get that message from the staff, and if you don't have the answer or whatever and want to throw it in to questions to send to us, we will definitely get back to you. If it's something immediately, we'll get back to you before the what do we do this?
Before the office hours. Yeah, but we welcome questions from your staff as well. So you're welcome to solicit those each month and then throw them at us at office hours.
Yeah.